Everybody's Christopher Small from CMS Law Firm, back again to talk to you about some estate planning, right? That's what we do here. But before I get into today's topic, which is sort of the powers that a power of attorney has, whether or not they can write a will for you if they are your agent, or if they can change your will, what they can do when it comes to amending and creating other estate planning documents. Before we get to there, I want to remind you that if you are interested in estate planning and learning about it, I've created a video. It's free. You can see it. It sort of outlines the foundational elements of a good estate plan. You can go to estateplanningvideo.com. Check that out. All right, so estateplanningvideo.com. Super simple. But the reason that this topic came up was I was talking to someone the other day. It was a potential client, and they were wondering about whether or not they could update or create actually a will for someone that they were the agent for. And as far as I know, this was coming from a good place. This person represented or was the agent for a family member who was elderly, very old, in their 90s, I think, had Alzheimer's, and was not able to create any estate planning documents because they no longer had the capacity to do so. And they didn't have a will, and there were some things that were going to happen via intestate succession, which is basically how your assets are distributed if you don't have a will. She had found out that some things were going to happen that she didn't believe her the person that she was representing would have wanted. And so she was calling to see if she could make a will for her person, for her I don't know what you call the person that's a power of attorney. She's the agent. They're like the person. That's what I'm calling them, the person. That's a legal term. But she was wondering if she could make a will for her person that would outline her the person's wishes, because she didn't think that what was going to happen without a will would have been in line with or congruent with what her person would have wanted when she died. And so we talked about it for a while, and I told her a couple of things. I said, first things first, look at the power of attorney document itself. So if you are an agent for someone and you have questions about what you can or cannot do, you always want to look at the document itself, because that is going to tell you a lot of what you can or cannot do, all right? It's typically all spelled out right there. If it is not spelled out in the document, then you probably cannot do it. It's not one of those things where if it's not in there, then you can. It's more like if it's not in there, then you can't. You cannot. All right, so look there first. That's the sort of the first point. The second point is, in most, if not all cases, the agent for a person is not going to be able to create or amend a will except for some very, very, very specific circumstances. And the reason for this is pretty clear if you really think about it. So, there's nothing really, our assets, the things that we've earned over our lifetime and the ability to send them to the people that we want are held, that power is held in pretty high esteem. And it is typically reserved just for the person that owns that property. And for that reason, power of attorney, the agents for a person, are not allowed to make a will. Because you could imagine a scenario where this person had in a previously made a will, and it doesn't work out the way that everybody else wants or that everybody thinks is right or fair. And so the agent is then tasked with sort of updating it to make it the way that it's supposed to be. When in fact, you as the person that's in charge of your assets get to do whatever you want with your stuff. When people come in, I tell them, I don't care what you do. You just tell me what you want to do. Tell me why you want to do it and what you're trying to accomplish. And I will give you some ideas, some suggestions, and a path to get there. But otherwise, I don't care. If you want to give everything to some dude on the street, that's fine. If you want to give everything to just one of your kids and cut all the other ones out, I mean, I don't know if I would do that myself, but I'm not you. And your stuff is not my stuff. So, you get to do with whatever you want. And so for that reason, the state or the law, right, whoever's creating these laws, the legislature, I guess, at the end of the day, they don't want to take the power of you as the individual out of your hands to give your stuff away to the people that you want. Now, with that being said, that's why it's critically important to create a will if you want to be in control of where you want your stuff to go. And it's really critically important to have an estate plan if you want to have control over your life, over your property, over the legacy of your family, and over pretty much anything else that has to do with you being incapacitated or dying. And if you want to know what all that looks like, by the way, if you want to a little bit of a deeper dive for free, it's a little video, go to estateplanningvideo.com and check it out. It's like a quick 20-point little PowerPoint voiceover thing that I created, but it basically will give you all of the elements of a foundational estate plan, the thing that everybody should have, and it'll tell you why you should have these things. Okay, so by the time you're done with that video, you're gonna know pretty much exactly what you need to get started, and you're gonna know why it's so important to have those things, okay? So once again, estateplanningvideo.com. All right, so at the end of the day, the answer to the question is no. What I was gonna say, but actually, let's back up a little bit. I did say there were some very narrow exceptions for the power of attorney to amend an estate plan, and those powers are typically reserved for changes that would relate to benefiting the estate from a tax perspective. So what can happen sometimes is because our tax laws are changing so frequently, is that let's say, for example, I made an estate plan today, and my goal was to keep estate taxes low and to benefit my family. And then let's say 10 years go by, all right? And in those 10 years, I have now become incapacitated for some reason, and there's been a major change to the tax law which makes my plan not work the way that I had originally intended it to work, right? For whatever reason. What the power of attorney does have the authority to do and the ability to do is to amend or change that estate plan so that the end result is the same, but the tax treatment, if it can be updated, is better. This can be a change in a trust structure, for example. It can be a change in other little things like that that are more on the legal side rather than on the where is everything going side. All right, so that's the one sort of power that the agent for someone via a power of attorney has when it comes to updating or changing a will or a trust or an estate plan in general. Okay, that's it. Once again, if you want the deep dive on estate planning, a quick deep dive, estateplanningvideo.com is where you want to go. You're going to hear my wonderful voice over some slides, and you're going to learn a lot about estate planning, pretty much everything that you need to know. There's no pressure, just giving it to you, all right? So once again, estateplanningvideo.com. Please go check it out. Otherwise, if you are watching this video and you like it, hit the like button. If you don't like it, hit the grumpy button or whatever, if there's a grumpy button. Leave me a comment. If you know somebody that needs this, share it with them. All right, but otherwise, I hope this really helped you out. Hope you got some helpful information, and hope you like my page or whatever, and come back and see me again, and you can have the opportunity to learn some more about estate planning. All right, close it up. I'm Christopher Small with CMS Law Firm. Have a great day.